statute gets in the way.
If I could, thanks.
Mom, this is EPC. You say one thing, I will speak.
Well, yeah, because I'm just doing this part of my course.
Yes, you got it. Oh, you're gonna wait? Oh, that's fine.
I'm sorry, this is where I my ego.
Ooh, okay.
Watch out for the cords.
Sorry about that.
No problem.
Ms. Jones has told me she has a few things she wants to say in closing statement.
I understand.
Okay, I'm sorry. I'm not going to belabor all the facts that we've heard today. You all have the letter of termination. You know clearly, I believe, what the county's position is as to what facts were presented today that support the findings that those violations, those 5 violations, were sustained. What I just wanted to mention is just more or less a reminder that, you know, what your job is as board members under your rules is that you are to determine whether or not the employee was guilty of the charges that he was charged with. And in discussing the penalty, if you disagree with the sheriff's decision, personally, that is not a reason to recommend a different penalty. Your job is to determine whether or not you shouldn't substitute your judgment and discretion for the judgment and discretion of the sheriff. If it has been demonstrated that the sheriff acted in good faith upon a fair investigation and imposed a penalty that was not inconsistent with those imposed in other cases. So if the penalty is considered obviously capricious or arbitrary, then you can recommend something different to the county manager, provided you find that the violations have been sustained. I think the testimony of the sheriff was very clear about what his reasoning was in this case versus other cases that were brought before you. I ask you not to rely on the testimony or the arguments of the council as to what the facts of those other cases were, but what the sheriff depended upon in making his decision. I think he was very forthright with you when he told you that maybe he had made a mistake with Deputy Sawicki and probably should not have allowed him a second chance after that last intent to terminate. And so I would just ask you to use your best judgment, judge the witnesses by those who may have something to gain in determining whether or not the facts have been established and the violations that he was terminated for have been proven. Thank you.
Yeah.
Yes.
I think that Ms. Jones' closing remarks points to something that we should try to focus on in part today. The sheriff said today that he made a mistake with respect to the discipline he gave to a deputy. Apparently, the sheriff's not infallible. Nobody said that he was, but apparently he makes mistakes when it comes to disciplinary decisions. He admitted that one was saying today. He said that he shouldn't have given Sawicki a second chance. He regrets that error. He thinks that he should have terminated him. So that indicates that some point, sometimes, the sheriff may make mistakes in making disciplinary decisions. I believe the evidence conveys that the mistake was made with respect to Mr. Deane. Now, you've heard Mr. Deane, very forthright, admitted from the beginning. He didn't just admit these things for the first time here today. He admitted it from the beginning that yes, you know, I don't remember what happened that night, but I committed a misdemeanor injurious to the public. Yes, you know, now that you show me the evidence, I guess I texted while driving. I used David for a purpose that wasn't permitted under the rules. He's been forthright from the beginning. There's no suggestion, no indication that he's been given any false testimony or that he's not been forthright. The sheriff's remarks in his termination letter to Mr. Deane were, well, I don't want to say they were wrong. Now, they certainly weren't intentionally so, but they were wrong. He found Mr. Deane to be evasive and not forthright in his interviews with AA about whether he allowed the girls to consume alcohol or whether the beer pong was played. Mr. Deane doesn't remember because Mr. Deane was intoxicated in the privacy of his own home, off duty. Every American, every person is free to do that as long as they're of age. He was of age, he exercised the right, probably in retrospect, not the best decision. He admits that inviting Kelly Caps to his party, not the best decision. But we all make mistakes in our lives. Everybody in this room has made mistakes. But I think that the penalty imposed in this case was, well, honestly, flagrantly harsh. And I'm glad that Ms. Jones pointed to it, but there's under page 21, page 23 of your own rules, it does admonish the board that it should not substitute its judgment and discretion for the judgment and discretion of the sheriff, only if the sheriff has demonstrated good faith upon a fair investigation and, this is the key language, and has imposed a penalty not inconsistent with those imposed in like cases. That's where we knock it out of the park, in my opinion. You've heard testimony from the sheriff that there were 3 deputies. They are Sawicki, they are Harvey, and they are Zimmer that I'd like to discuss with you here today. Zimmer punched a child. Now, the child may not have been a young waif, but he was a teenager. Punched a child 3 times in the face, injuring the child. Okay? Chipped his tooth. Now, the sheriff, and I guess what I think doesn't matter that much, but for what it's worth, I can't see how on God's green earth anyone can say that punching a child, a teenager, in the face 3 times and injuring that child is less significant than the violations that man is accused of. He got drunk and he let some girls at his party drink some alcohol. Well, admittedly, not good. Admittedly, bad decision. Admittedly, misdemeanor injurious to the department. But even the law recognizes that what Mr. Zimmer did and what Mr. Deane did aren't, well, the law recognizes that what Mr. Zimmer did was worse. And what Mr. Deane did wasn't as substantial. How do they recognize that? Well, the law, and no one can contest this, recognizes battery as a first-degree misdemeanor punishable by 1 year in jail. The offense that he committed, that he admitted committed, 60 days in jail. So if the state of Florida recognizes that what Mr. Zimmer did was more significant, apparently much more significant than what Mr. Deane did, I can't see how the sheriff didn't, and I can't see how you won't. I can't see it. It doesn't make any sense. So you're obligated to look at whether or not he imposed discipline that was overly harsh. You're obligated to look at whether or not he imposed discipline that was inconsistent with similar cases. He gave Zimmer a suspension for 30 days. 30 days for punching a kid in the mouth 3 times. I'm sorry. Thought of that happened. And my client commits a second-degree misdemeanor punishable with 60 days in jail, and he gets terminated. His previous disciplinary history, 2 written reprimands. Not once was he suspended for any offense at all. And we've already dealt, in my mind, with that 1 letter of written reprimand for sending that 1 suspect's property to evidence rather than to the jail, as is required by policy. Sergeant McGuire testified that he ordered them to do it, and that he followed Mr. Deane, a lawful order. So we take, in my mind, one of those offenses that he committed out of it completely, and you're left with a letter of reprimand for careless use of a vehicle. That's his disciplinary history. And look at that man's performance history. You see the performance evaluations. His last performance evaluation before he was terminated was nothing less than stellar. Not 1 meets expectations. Certainly not 1 anything below that. All exceeds and 1 outstanding. How many deputies get evaluations like that? Not many, I would wager. This man doesn't compare with Zimmer in respect to the discipline that was imposed. He committed less discipline and to receive less punishment than Zimmerer did. I think a blind man should be able to see that. Now let's talk about Sawicki. Sawicki threatens to kill his girlfriend. He also assaults his girlfriend. First-degree misdemeanor, punishable by a year in jail. He had previously been suspended for 40 hours for similar type of activity, apparently not learning the lesson that he was given the first time. What does he get the second time? Another suspension, last chance agreement, not terminated. Sheriff makes me made a mistake. He made a mistake here too. How can the state of Florida see what Sawicki and what Zimmerer did as worse than what Deane did, and the sheriff not see it? I ask you to look at the difference, look at the distinction, and hone in on it, and make a decision based upon that glaring disparity. Now the sheriff wants to talk about texting while driving and a David violation. Sure, he shouldn't have done those things. But a one-time texting while driving, a one-time use of David, somehow maybe not handling the arrest of Stephen DeHutt exactly the way that the sheriff sees that it should have happened. Is that enough to outweigh what Zimmerer did, or to even approach what Zimmerer did? Is enough to outweigh what Sawicki did, or even measure up to what Sawicki did? No. No. It's not logical. It's not possible. It's not rational. I'm asking you to exercise independent judgment. Exercise common sense and find that the sheriff's termination of this man was overboard, and recommend to the county manager that he receive lesser discipline. I could talk about Harvey, but that would be beating a dead horse I spoke about earlier. Harvey committed a DUI, leaving the scene of an accident with property damage, both first-degree misdemeanors. What's he get? 30 days in jail. I apologize today if I got a little frustrated, because this is one of those cases I feel very strongly about. What the sheriff did, with all due respect to him, I like the man, I respect the man, I certainly respect the work that he does. But this decision, it doesn't have any common sense attached to it, not in comparison with the other discipline that's been imposed on others. And your obligation under the rules is to see if this discipline was inconsistent. It's there in the rules for a reason. There's a specific obligation on you. And I ask that you exercise it and give the county manager a recommendation that a lesser punishment determination be imposed. Thank you.